Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 67 in the series Indian Polity. In today's lecture, we are going to understand the powers and functions of the governor. It's almost the replica of what you have seen with regard to the powers of the president. So you already understood as to what are the various powers and functions of the president. In a similar manner, we are also going to understand as to what are the powers and functions of the governor in this particular lecture. We have seen that the president under the Constitution of India exercise different types of powers. And what are the various types of powers he exercises? He exercises powers which are executive in nature. We have seen the powers exercised by the president which are legislative in nature. We also seen powers which are judicial in nature, and then of course we have seen his diplomatic powers, and we have also seen the president having certain military powers, and of course the most important thing, the emergency powers of the president as well. So today under the topic of governor, we will also try to understand all these things. But however, we'll have to understand when you see that the governor being the constitutional head of the state, he exercises almost similar power as that of the president at the union level, but however, it is not the same. I am using the word similar but not the identical power, because the governor under the constitution does not exercise what is called as the emergency powers. He also does not exercise what is called as the military powers, and he also does not exercise what is called as diplomatic powers. So the military powers, the diplomatic powers and the emergency powers are exercised only by the president of India. But however, the governor exercises similar powers as that of the president with regard to what is called as the executive power, the legislative power and the judicial power. So let us try to understand that one by one. So first we are going to understand as to what is the executive powers of the president. To put it in a very simple way as to what are the executive powers of the president, if you will understand the executive powers, these are all powers which are all executive in nature. Say for example, these are all powers referring to seeking the information from the chief minister and the council of ministers. These are all powers related to appointment of various executives. So such powers are in the nature of what is called as executive powers. So what are the various executive powers exercised by the governor? First and foremost thing that you have to understand, because the governor is the head of the state executive, all the executive actions are formally taken in his name. So in whose name all these actions are taken? All the executive actions are taken in the name of the governor, because we already seen that the governor is the head of the state executive. In fact, it is not only that all the executive actions are taken in the name of the governor. In fact, it is a governor who make rules for the convenient transaction of business of the state government. So when I say for the convenient transaction of the business of the state government, in fact, this power is exercised by the governor under Article 166 of the Constitution, similar to that of the power that is exercised by the president under Article 77. But what does it mean making rules for convenient transaction of business is something that you have to understand. When we say that making rules for convenient transaction of business, it means it is a governor who will decide as to what shall be the administrative structure of the state government. When I say administrative structure of the state government, it is a governor who get to decide as to how many departments shall be there, how many ministries shall be there, who would head each and every ministry, what shall be the delegation of authority to different people, how the files shall get authenticated. So all these things are decided, and the administrative work is carried out based on the rules that is made by the governor, because such a power is conferred upon the governor by virtue of the constitution. But however, is it a discretionary power of the governor? No, it is not the discretionary power of the governor. This power is given to the governor, or this power is exercised by the governor rather on the basis of what is called as the aid and advice of the council of ministers. That's exactly what you'll have to understand. So the governor make rules for more convenient transaction of business. So that is a very, very important executive function of the governor. And it is also the governor who make important appointments in the state government. Say for example, it is a governor who makes appointment to the State Finance Commission. It is the governor who makes appointment to the State Election Commission. Apart from it is the governor who will appoint what is called as the advocate general of the state. So similarly, it is not restricted only to this. A number of state level commissions, if you see who is going to make the appointment, all these appointments are made only by the governor of the state. So that is what basically that you'll have to understand, which is all part of his executive powers. Apart from that, the governor has also the authority to seek information from the State Council of Ministers. In fact, if you look into the constitution says that the Council of Ministers, or to be very specific, the Chief Minister should inform the governor with regard to the various administrative affairs of the state. So the Chief Minister has to inform this on a regular basis to the governor with regard to the proposals for legislations, with regard to the policies that the government has taken for the welfare of the people. So these things has to be updated to the governor on a regular basis. But in case if the Chief Minister failed to do this, it is also possible for the governor to ask a report from the Chief Minister or any of the Council of Ministers. So that is again part of his executive powers. And then apart from all those things, very, very important thing, the governor also has the power to recommend the President of India to impose what is called as the President rule in a particular state. Now this we have already seen with regard to Article 356 of the Constitution. If you see Article 356 of the Constitution, Article 356 of the Constitution is giving the power to whom? It is giving the power to the President to impose a President rule in a particular state. And what is the condition on which the President rule can be imposed? The President rule can be imposed on the ground if there is a constitutional breakdown in that particular state. In fact, what can be seen as constitutional breakdown? I already explained this, because the term constitutional breakdown is nowhere defined in the Constitution, but what can be seen as constitutional breakdown are certain conditions which can be seen as what is called as constitutional breakdown. Especially when the state government loses majority, that can be seen as a constitutional breakdown. Not only loss of majority, if the state government, there is a large scale law and order failure, that can be seen as what is called as a constitutional breakdown. Or if the state government is carrying out administration which is anti-secular in character, so that can be seen as a constitutional breakdown. So now try to understand that if the state government is not carried out in accordance with the provisions of the Constitution, or in other words, there is a constitutional breakdown, it is the responsibility of the governor to send a report to the President under Article 356. And what is the report that the governor will send? The governor will record all the things that is happening in that particular state, where he will also say that there is a constitutional breakdown in the state. So therefore, he recommends the President to impose what is called as a President rule in that particular state. So this is again the power of the governor under Article 356. But however, please note it in your mind. The most important thing that you have to remember is, as per the Constitution, it is not mandatory for the President to wait for the report of the governor. Whether the governor sends the report or not, even otherwise also without a report, the President can impose what is called as a President rule in a particular state, provided there is a constitutional breakdown in that particular state. So these are all the basic things that probably you will have to keep it in your mind. Alright, so all these things are what is called as part of the executive power of the President. Sorry, the executive power of the governor. But the governor is not only exercising the executive powers, being the executive head of the state, he also exercises certain powers which are legislative in character. So now we are going to the legislative powers of the President. Governor. In fact, the legislative power of the governor is almost similar to that of the legislative powers of the President. But however, let us try to understand as to what are the various legislative powers of the governor in a particular state. In fact, first and foremost thing that you have to keep in your mind is the governor is an integral part of the state legislature. When I say the governor is an integral part of the state legislature, he is very much within the part of the state legislature, or in other words, if you see as per the Constitution, what are all the constituent part of the state legislature? A state legislature definitely has a state legislative assembly. And if there is a council in a particular state, the legislative council is also part of the state legislature. Apart from that, the Constitution also says the governor is also an integral part of the state legislature. So these are the things that is part of the state legislature. It includes the governor plus the legislative assembly of that particular state. So every state under the Constitution should have a legislative assembly. But we know that having a legislative council is not mandatory. Do we need to have a legislative council in a particular state? Having legislative council, as I said, is not mandatory, but in case if the legislative council is there, the legislative council is also part of the legislature. So you have the governor, you have the legislative assembly, plus you have what is called as the legislative council. So these things are the integral part of the state legislature. In fact, why the governor is considered to be an integral part of the state legislature? Because without the governor, the legislative assembly or the state legislature will not be able to fulfill its functions and responsibilities. For example, lawmaking is an important function of the state legislature, but without the governor giving the assent, the bill does not become an act. And without the governor summoning the sessions, the legislative assembly members cannot meet in the first place. So therefore, the governor plays an important role with regard to the legislature performing its duties and responsibilities. And hence the governor is also considered to be an integral part of the state legislature. But however, keep this in your mind that the governor is an integral part of the state legislature, but he is not a member of the state legislature. So this is something that you'll have to keep it in your mind. Apart from that, it is also the governor who is going to summon, prorogue and dissolve the house. What does it mean by summoning the house? Summoning of the houses means calling upon the members to start a session. So who is supposed to call upon the members to start the session of the state legislature? It is the governor who has to summon and call upon the members of the state legislatures to start a session. But however, try to understand, summoning the members of summoning the session of the state legislature is not a discretionary power of the governor. It is based on the aid and advice of the state council of ministers. Similarly, what does it mean by prorogation? So prorogation means termination of a session. Summoning means starting a session. Prorogation means termination of a session. So that means within the term of the legislative assembly, the term of the legislative assembly is usually 5 years. Within this 5 years time, multiple times the sessions can be summoned and can be prorogued. Whenever a particular agenda is over for that particular session, the session is terminated. Say for example, most of the state legislature in our country, they follow the same session as that of the parliament, the budget session, the monsoon session and probably the winter session. But however, the constitution does not prescribe any specific number of sessions. So it is all based on the conventional practices that they have the session and the prorogation of the session. And then it is also the governor who can dissolve the house. So when I say the governor can dissolve the house, the governor can dissolve the legislative assembly because there's a term for the legislative assembly. The term of the legislative assembly is normally 5 years. The legislative assembly can also be dissolved earlier. When it can be dissolved earlier? When there's a no confidence motion against the government or if the government resigns suddenly. So therefore, it can also be dissolved earlier. But however, keep this in your mind. So which house can be dissolved? Only the legislative assembly can be dissolved in a particular state. Because in a state, if there's a legislative council, the legislative council would be a permanent house. Similar to that of the Rajya Sabha in the union legislature, here if a legislative council is there, the legislative council is a permanent house and hence it cannot be dissolved. So only the legislative assembly can be dissolved. In fact, apart from all these powers, it is also possible for the governor. This is very, very important. It is also possible for the governor to send messages to both the houses of the parliament. Okay. Now, before I get into this particular topic that the governor can send messages to both the houses of the parliament, what is something that you'll have to keep in your mind? Is that the only thing that is given in the constitution with regard to summoning, prorogation and dissolution is that the constitution makes it very clear that the gap between two sessions, that is prorogation of a session and the summoning of a new session, the gap between these two things should not be more than a period of 6 months. This is the only thing that the governor has to keep in his mind, or in other words, that the recess in the state legislature should not be more than a period of 6 months. So this is the thing that the governor has to keep in mind. When I say the governor has to keep in his mind, not necessarily the governor, but the council of ministers have to advise him in such a way that between the termination, that is prorogation and summoning of a session, there shall not be more than 6 months. But apart from that, there is no mention in the constitution as to how many days the sessions have to be there, how many days the MLAs have to meet, how many sessions has to be there. Nothing is prescribed in the constitution. Apart from that, the governor can send messages to both the houses of the parliament anytime. And in fact, He can address both the houses of the parliament together or separately also. This he can do it at any time. But however, under the constitution, the governor does make what is called as a special address, addressing both the houses of the parliament. This special address is done only on 2 occasions. So what are the occasions on which he does the special address? The first occasion on which he does the special address is whenever the election to the legislative assembly is over and a new government is formed. So I'm repeating it again. Whenever the election to the legislative assembly is over and a new government is formed, when the new government is formed, there will be a first session in the house. So when the new government is formed, in the first session, the governor makes a special address. So this is one. And every year in the first session. So every year in the first session, what would be the first session in every year? It is normally the budget session. So one first session every year, that is a budget session, and after the election is over, the first session, the governor makes an address. And what is the special address that the governor makes? The governor, during the first session after the election to the legislative assembly is over, he provides or he presents the agenda of the government for the next 5 years. So basically, this is not a speech which is prepared by the governor, but it is a speech which is prepared by the government. And on behalf of the government, the governor presents this particular speech. And it is just like the agenda of the government for the next 5 years, wherein he will put it across to the other members of the legislature as to what the government wanted to do for the next 5 years. So this is one special address he makes. And then the governor makes a special address during the first session every year, that is a budget session, wherein he presents a report card of what the government has achieved in the previous year. So both occasions, the governor address both the houses of the parliament. And once the governor presents this special address, what you'll have to keep it in your mind, this is not a speech which is prepared by the governor, but rather he merely presents whatever is prepared by the government. And once he presents this particular speech, after he presents this particular speech, to thank the governor for his address. So this is what is likely to happen. To thank the governor for his address, the motion is introduced in the house. And what is a motion that is introduced in the house? There is something which is called as motion of thanks, which is introduced in the house. So this motion of thanks is usually introduced by the government. Any minister in the house will introduce this. Sometimes it can be introduced, or most of the times it is even introduced by the chief minister in whichever house he is a member. So mostly in the legislative assembly, and another minister from the legislative council will also introduce a motion of thanks. So the governor, after making a special address, to thank the governor, a motion of thanks is introduced, and this motion of thanks is introduced separately in both the houses of the state legislature. In case if there are 2 houses, if there are no 2 houses, in the legislative assembly it is introduced. The purpose of the motion of thanks is to thank the governor, and then once the motion is introduced to thank the governor, there will be an elaborate discussion, because this motion of thanks is related to the governor's speech. So there can be some members in the legislature who may not approve the speech made by the governor, so they may have disagreement. So to that extent, there can be discussions in the house on this particular matter. And then subsequently, after the motion of thanks is introduced and after all the discussion is over, the motion of thanks is put to vote. And if the motion of thanks is not passed with simple majority, then it is considered that the government is not having the majority. Or in other words, it is considered that the government has faced what is called as a no confidence motion, and it is passed against the government. Therefore, if the motion of thanks is not passed, then the government has to resign. So it is very, very important that this motion of thanks is passed in the state legislature, to be very specific, in the state legislative assembly. So similarly, the motion of thanks is also introduced in what is called as the legislative council, in case if the state is having a legislative council. So if in the legislative council, if it is not passed, it does not have any impact upon the government. But if it is not passed in the legislative assembly, then the government has to resign, because it is automatically deemed or considered to be what is called as a no confidence motion. Apart from that, it is also the legislative power of the governor to nominate members to what is called as the legislative council. Remember that the president has nominated 12 members in the Rajya Sabha. So similarly to the legislative council, the governor nominates 1/6 of the members. Whatever is the size of the legislative council of that particular state, 1/6 of the members are to be nominated by the governor. So this is again an important power. And it is also the governor who can give assent to the bills. So whenever the bills are presented to the governor, The governor can give the assent, the governor can withhold the assent, or he can send it for reconsideration. So he almost exercise similar powers as that of the president. So this is again a very important legislative powers of the governor. Apart from these three powers, that is, the governor can give the assent, the governor can withhold the assent, and the governor can send it for reconsideration. A similar thing we already seen in case of the president. If the governor gives the assent, the bill becomes an act. If the governor withholds the assent, the bill does not become an act. If the governor send it for reconsideration, then if the bill is again sent back by the legislature, then the governor has to give the assent. Now, apart from these three options, there is also one more option that the governor can exercise, is the governor can reserve the bill for the consideration of the president. This is very, very important. Reserve the bill for the consideration of the president. So, in which case the governor can reserve the bill for the consideration of president. In fact, reserving the bill for the consideration of the president is the discretionary power of the president. That means whenever the governor thinks, he can reserve any bill for the consideration of the president. Under the constitution, it is mandatory for the governor to reserve the bill for the consideration of president in one case. That is, if any bill is passed by the state legislature, it is impacting or it is going against the powers of the High Court concerned, or it is affecting the powers of the High Court concerned. In that particular state, it is mandatory for the governor to reserve the bill for the consideration of the president. In all other cases, whether to reserve a bill for the consideration of the president or not, it is a discretionary power of the governor. When I say discretionary power of the governor, he doesn't have to act in accordance with the aid and advice of the Council of Ministers. So what is a mandatory condition under which he has to reserve the bill for the consideration of the president? The only case it is mandatory is if the bill derogates the powers of the High Court concern. In all other cases, it is the discretionary power. All right. So what are the options that the governor can exercise? The governor can exercise four options. Give the assent to the bill, withhold the assent to the bill, send it for reconsideration, but if it is sent back, then the governor has to give the assent. 4, he can also reserve it for the consideration of the president. Reserving it for consideration of the president is a discretionary power of the governor. In one case, it is mandatory when the bill is in derogation with the powers of the High Court concern. In all other cases, it is his discretionary power. So once a bill, let us assume it is sent to the president for his assent, then the fate of this particular bill will be decided only by the president. So once a bill is reserved for the consideration of the president, the governor has no role in this particular regard. So who is going to decide whether the bill will become an act or not after that? It is for the president to decide whether the bill will become an act or not. So once a bill is reserved for the consideration of the president can exercise certain option under Article 201 of the Constitution. Under Article 200 of the Constitution, the governor can reserve the bill for the consideration of the president. Once reserved under Article 201 of the Constitution, the president can exercise certain options. What are the options the president can exercise? The president can give the assent to the bill. The president can give the assent. The president can withhold the assent to the bill. So he can also withhold it. And the president can send it for reconsideration. So send it for reconsideration. So this can also be done by the president. So if the president gives the assent, then the bill becomes an act. If the president withholds the assent, the bill does not become an act. If the president send it for reconsideration, then the state legislature has to look into that particular bill, send it back to the president within a period of 6 months. So what is the time limit for the state legislature to send it back to the president? They have to send it back to the president within 6 months. But however, the important point that you have to notice, even after it is sent back, further after the reconsideration to the president, it is not mandatory for the president to give the assent. That means the president can send it any number of time for reconsideration to the state. And whenever it is sent back, it is not mandatory for the president to give the assent. So these are all the important points that you'll have to keep it in your mind. So very quickly, so what are the powers in the hands of the governor? The governor can give the assent, he can withhold the assent, he can send it for reconsideration, or he can reserve it for the consideration of the president. Now once he reserves it for the consideration of the president, who will decide the fate of that particular bill? Henceforth, it will be decided by the president. And what options can be exercised by the president? The president can give the assent, the president can withhold the assent, and the president can send it for reconsideration. If the president sends it for reconsideration, the bill has to be again sent back by the legislature to the president within a period of 6 months. But even in this case, it is not mandatory for the president to give the assent. So these are all important powers that you'll have to keep it in your mind. The last legislative power that is exercised by the president is the president can also promulgate what is called as ordinance. It is same as that of what I have discussed in case of the president. So here the only difference is while the president promulgates ordinance under Article 123, the governor promulgate ordinance under Article 213 of the Constitution. Just we'll have to replace the word president by governor. And then we have to replace the word parliament by state legislature. That means while the president can promulgate ordinance on all the areas on which the parliament can make laws, the governor can promulgate ordinance on all the areas on which the state legislature can make laws. So this is the thing that you'll have to keep in your mind. And most importantly, that whenever an ordinance is issued, we have already seen under what circumstances the ordinance can be issued. That either both the houses of the state legislature is not in session, or at least one of the houses of the state legislature is not in session, and there is an immediate requirement to make a law. Under such a circumstances, an ordinance can be issued. But try to understand this ordinance making power is not a discretionary power of the governor. It is based on the aid and advice of the Council of Ministers. Now, whenever an ordinance is issued, it is very important that the ordinance is placed for the approval of the state legislature. And as per the Constitution, within how much time this ordinance has to be approved? The ordinance has to be approved within a period of 6 weeks. So within a period of 6 weeks, the ordinance has to be approved. And once approved, it automatically becomes a law, even before the 6 weeks. 6 weeks from the time the state legislature comes into session. And even before these 6 weeks, the ordinance can be revoked by the president by the governor at any point of time. So these are all some basic understanding that you'll have to keep it in your mind. And further, the Supreme Court has made it very clear that the ordinance making power of the governor is subject to what is called as judicial review. So therefore, this ordinance making power should not be misused. And further, the Supreme Court has very categorically said that the re-promulgation of ordinance is a fraud upon the constitutional power. So while you can promulgate ordinance, that is not an issue, but you cannot keep on issuing the same ordinance again and again when the time is about to expire. Then when you keep on, in essence, promulgating the same ordinance again and again, then it becomes re-promulgation of an ordinance. So re-promulgation of ordinance means that you are using the law-making power parallelly to that of the law-making power of the legislature. So the ordinance making power as per the constitutional provisions is to be used not as a parallel power. It is to be used only when the legislature is not in session. So therefore, the Supreme Court has clearly said the re-promulgation of ordinance is a fraud upon the constitutional powers of the governor. So re-promulgation should not be done. Only what can be done is promulgation of ordinance. Now we are moving to the next power of the governor, that is basically what is called as a judicial power. So we have understood the executive powers, we have understood the legislative powers. So now we are moving on to what is called as the judicial powers of the president. So when I say the judicial powers of the president, judicial powers of the governor. So many times I use the word president. So please make this particular correction. In case if I use the word president instead of the governor, understand that I am talking about the governor. So if you see the judicial powers of the governor, so the only difference here is that instead of Article 72, which gives the pardoning power to the president, Article 161 gives the pardoning powers or the judicial powers to the governor. It is for the same reason, to rectify the judicial mistake, this pardoning powers or judicial power is given to the governor. Similar to that of the president, the governor also exercises similar pardoning powers. Of course, some slight difference is there, which I will explain. But if you see the nature of powers which is exercised by the governor is similar to that of the president. The governor has the power to pardon, power to commute, the power to remit, the power to reprieve, and the power to respite. Now, what does it mean by pardon? Pardon means completely letting an individual free, irrespective of the punishment. What is commutation or commute? Commutation or commute means reduction in punishment with change in character. Say, for example, death punishment to life imprisonment. And then what do we mean by remit? Remit means reduction in punishment without change in character. Say for example, 10 years of rigorous imprisonment to 5 years of rigorous imprisonment. There is reduction in the punishment but no change in character. Reprieve. Reprieve means temporary stay on the execution of the punishment. This normally happens whenever a capital punishment is given to an individual. When a capital punishment is given to an individual, therefore, when somebody applies to a mercy petition to the governor can reprieve this particular punishment, which means he is putting a temporary stay on the execution of the punishment till the time he disposes the mercy petition. And then the last thing is respite. Respite is temporary relief that is given to an individual who is in jail. Now try to understand, first of all, because I've already covered the pardoning powers of the president. It is easy for the students to understand if you watch the pardoning powers of the president and then come to the pardoning powers of the governor. But if you have not watched it, try to understand when these pardoning powers can be exercised by the president or the governor. All the pardoning powers can be exercised either by the president or the governor by a convict who is convicted in a court of law, who is undergoing a punishment, only after he has exhausted all the judicial remedies. So all the judicial remedies are exhausted. There is no further judicial remedy. That they have gone to the Supreme Court also and they have exhausted all the remedies. Then they can come for the mercy petition. So that is when they can exercise the pardoning powers. And there are different types of pardoning powers. Although we call that as pardoning power, different types of powers are exercised. As I already said, pardon, commute, remission, reprieve, respite. So in which cases the governor can exercise all these powers? So first of all, you'll have to understand the governor has no power with regard to court martial. So these are all the areas where the governor has no powers. So try to understand this. So the governor has no power with regard to court martial. That means if any person is given a punishment through the court martial procedure. Court martial means the trial is conducted according to the military laws in a military court. So that punishment may be given to a civilian or to a military personnel, but they violated the military laws in our country. So therefore, they are punished through what is called as the court martial or through the military courts and not through the civilian courts. In such cases, somebody is punished through what is through the process of court martial. You'll have to understand. In such cases, it is very, very important that they do not have any mercy petition or they cannot apply for the pardon to the governor, but they can go only to whom? They can go only to the president and not to the governor. So this case, there is no pardoning power to the governor. Second, where there is no pardoning power to the governor is death punishment or capital punishment. Suppose let us assume somebody is given a capital punishment or a death punishment. Can they go to the mercy petition to the governor? No. They can go to the governor, but the governor has no power to pardon it. That is what is very important. Can the governor pardon it? No. Pardoning means completely setting an individual free. It does not matter based on which law an individual is given a capital punishment. Irrespective of the punishment that is given to an individual, that is irrespective of the law based on which the punishment is given to an individual, whenever a capital punishment is given, in that particular case, they can go only to the president to seek pardon, not to the governor. The governor, I'm repeating it again, the governor has no power with regard to what is called as pardon. But however, they can go to the governor in case of capital punishment or death punishment, and they can seek the commutation of the capital punishment. Commutation means reduction in punishment. Pardoning means completely setting an individual free. So to the governor, they cannot go and seek pardon, but they can go and seek commutation of a capital punishment, but provided the capital punishment is given to the person based on the law made by the state legislature. This is what is very important. So in which case they can go to the governor if the law is based on if the punishment is based on the law made by the state legislature, or in other words, the punishment is based on the executive powers of the state, or in simple words, where it is based on the law made by the state legislature. So try to understand in which cases they cannot go to the governor. They cannot go to the governor in case of what is called as court martial. Nothing in case of court martial. In case of capital punishment, if the capital punishment is based on the law made by the parliament, they cannot go. But if the capital punishment is based on the law made by the state legislature, then they can go to the governor, but the governor cannot pardon it. But what he can do, he can commute the capital punishment, provided it is based on the law made by the state legislature. Commute means he cannot completely set the individual free, but reduce the capital punishment to life imprisonment. That he can do, provided it is based on the law made by the state legislature. Now, the last thing is, if it is not a capital punishment, if it is a punishment apart from capital punishment, it can be life imprisonment, 10 years of imprisonment, 7 years of imprisonment, whatever it is. But the punishment is not what? But the punishment is not a capital punishment. In this particular case, if the punishment is not a capital punishment, if the punishment is any of the other punishment, but provided it is based on the law made by the state legislature. That means based on the law made by the state legislature, if an individual is convicted in a court of law and he is punished in a court of law, whatever may be the punishment except the capital punishment, in all those cases they can go to the governor, and the governor can exercise any of these powers, including the power to pardon. So the governor power to pardon does not, or governor power to pardon or any of the other things does not extend in case of court martial. The governor power to pardon does not extend in case of capital punishment. But the governor power to commute a capital punishment will extend in case of the law made by the state legislature. And in all other cases, whatever may be the punishment except the capital punishment or the court martial, the governor will have all the powers. He has the power to pardon, commute, remit, reprieve, respite, provided the punishment is based on the law made by the state legislature. So this is the basic understanding you should have. So try to keep it very simple. Try to listen one more time in case if you are not able to comprehend. So this is a basic understanding you should have with regard to the pardoning powers of the governor. And in fact, this is not the only judicial power of the governor. Apart from that, the governor also appoints the judges of the district courts in the state, and also certain other judges. So all these things are done by the governor. So these are all considered to be the judicial powers of the governor. In fact, try to understand one more important thing, that similar to that of the president, the governor exercises all these powers, but the governor under the constitution does not have any emergency powers. The governor under the constitution does not have what is called as military powers and the diplomatic powers. So with that, we are coming to the conclusion of the discussion of the governor. So before I complete the entire discussion, I wanted to make one small comparison between the constitutional position of the governor and the president, for which we'll have to understand Article 74 and Article 163 of the Constitution to understand what is the constitutional position of the governor and the president. If you see Article 74 of the Constitution, it says that there shall be a council of ministers headed by the Prime Minister to aid and advise the Prime Minister, who shall act in accordance with such advice. I am repeating it again. Article 74 of the Constitution is saying that there shall be a council of ministers headed by the Prime Minister, who shall advise, or to advise the Prime Minister, to advise the President, who shall act in accordance with such advice. That means with respect to Article 74 of the Constitution, that there shall be a council of ministers to advise the President and whose advice is binding upon the President. But whereas when you talk of Article 163 of the Constitution, Article 163 of the Constitution says that there shall be a council of ministers headed by the Chief Minister to advise the governor in exercise of his function, except in those areas where he can act in his discretion. So this is the way the article is designed. I am repeating it one more time, so try to understand this. Article 163 of the Constitution is saying that there shall be a council of ministers at the state level headed by the Chief Minister to advise the governor in exercise of his functions, except in those areas where he can act in his discretion. That means the Constitution is making it very clear, while the President is bound to act in accordance with the aid and advice of the Council of Ministers in most of the cases, whereas the governor is to act in accordance with the aid and advice of the Council of Ministers only in those areas where he has to act in accordance with such advice. Or in other words, in those areas where he can exercise his discretion, the governor, he doesn't have to act in accordance with the aid and advice of the Council of Ministers. That means one thing is very clear, there are more constitutional discretions. There are explicit constitutional discretion that is given to the governor under the Constitution, which is not the case with regard to the President. Or in other words, who is having more constitutional discretion in the constitution? The governor is given more constitutional discretion because the constitution is making it very clear the aid and advice is given to the governor in exercise of his functions except in those areas where he can exercise his discretion. So what are the areas under which the governor exercises discretion? At least two important areas where the governor can exercise his discretion. One is Article 200 of the Constitution, while reserving the bill for the consideration of the president. We have already seen that one of the options that the governor can exercise is he can reserve the bill for the consideration of whom? He can reserve the bill for the consideration of the president. So which bill he will reserve for the consideration of the president is his discretionary power. So in this area, he doesn't have to act in accordance with the aid and advice of the Council of Ministers. Second thing is where he can act in his discretion is under Article 356. When the governor feels that there is a constitutional breakdown in that particular state, then he can send report to the president to impose what is called as a president rule. In this area also, he has got what is called as constitutional discretion. So that doesn't mean that the governor has got only constitutional discretion. The governor can also exercise what is called as situational discretion. Now, before I get into situational discretion, the governor also acts independently when he is an administrator of an adjoining union territory. So, for example, if the Tamil Nadu governor is also the lieutenant governor or an administrator of an adjoining union territory, let us assume Puducherry. With regard to administration of Puducherry, he doesn't have to act in accordance with the aid and advice of the Council of Ministers. So, that is again a discretionary power. So, the governor under the Constitution not only exercise what is called as constitutional discretion, but he may also exercise certain situational discretion. The difference between constitutional discretion and situational discretion is constitutional discretion is explicitly given in the Constitution, whereas situational discretion is not explicitly mentioned or given in the Constitution, but when the situation arises, the governor probably can exercise this discretion. Say for example, when there is a hung assembly in a particular state, after the election is over, no party is able to form the government. Then under such a situation, when there is no obvious leader or no party is having a majority, under such a situation, the governor can exercise his situational discretion in appointing the chief minister in that particular case. So this is a situational discretion. When any government loses majority, then the governor can dismiss that particular government. That is a situational discretion. And apart from that, if a CM suddenly dies, when the chief minister suddenly dies and there is no obvious successor, then also the governor can appoint what is called as a new chief minister. So these are all some of the situational discretion. When I say that the governor can appoint a new chief minister, he can appoint anyone as a chief minister provided there is no obvious successor in the party. And then he may ask the chief minister to prove the majority within a specified time. So these are all some of the situational discretion that the governor exercises. So if you look into the constitutional position between the president and the governor, who is having more constitutional discretion is of course the governor. And of course, apart from that, the governor also exercises certain situational discretion similar to that of the president, who also exercise some situational discretion. So with that, we are almost coming to the end of today's lecture. Very, very important. So we have tried to understand the various powers and functions of the governor, how and to what extent it is similar to that of the president, and where there is a difference, especially with regard to the pardoning powers. Please make a note of those things. So with that, please come to the particular question. It will be an easy question to answer if you have listened to the lecture carefully. Consider the following statement as per the Constitution of India. Statement 1. The governor has a discretion to appoint the chief minister under all the circumstances. Is it under all the circumstances or it is only in certain situations? So try to answer this statement. The governor has to act in accordance with the aid and advice of the Council of Ministers under all the circumstances. Is that required? The governor appoints the judges of the High Court concerned. Does he appoint the judges of the High Court? Which of or how many of the statements given above are correct? 1 only, 2 only, 3 only, none of the above. Please put your answers in the comment box. If you like this video, please share it with your friends and family members. And I'm quite sure it is going to be extremely useful to the students preparing for the UPSC IAS examination and other competitive examination. Please do share this video. Thank you very much for watching this particular video. All the best.